Case 62, Gilmore versus Gonzales. We find ourselves here in the Ninth Circuit U.S. Court of Appeals. Facts. On July 4, 2002, Gilmore, a California resident and U.S. citizen, attempted to fly from Oakland International Airport to Baltimore Washington International Airport on a Southwest Airlines flight. Gilmore intended to travel to Washington, D.C. to petition the government for redress of grievances and to associate with others for that purpose. He was not allowed to fly, however, because he refused to present identification to Southwest Airlines when asked to do so. That same day, Gilmore went to San Francisco International Airport and attempted to buy a ticket for a United Airlines flight to Washington, D.C. While at the ticket counter, Gilmore saw a sign that read, "Passengers must present identification upon initial check-in." Gilmore again refused to present identification when asked by the ticketing agent. The agent told him that he had to show identification at the ticket counter, security checkpoint, and before boarding, and that there was no way to circumvent the ID policy. A United Airlines service director told Gilmore that a United traveler without identification is subject to secondary screening, but did not disclose the source of the identification policy. United's ground security chief reiterated the need for ID, but also did not cite the source of the policy. The security chief informed Gilmore that he could fly without presenting ID by undergoing a more intensive search, in other words, by being a selectee. A selectee search includes walking through a magnetometer, being subjected to a handheld magnetometer scan, and having a light body pat-down, removing one's shoes, and having one's carry-on baggage searched by hand, and a CAT scan machine. Gilmore refused to allow his bag to be searched by hand, and was therefore barred from flying. Gilmore left the airport and has not flown since September 11, 2001, because he is unwilling to show identification or be subjected to the selectee screening process. Gilmore filed a complaint against defendants in the U.S. District Court for the Northern District of California, challenging the constitutionality of several security measures, which he collectively referred to as the scheme, including the ID policy, CAPS and CAPS 2, and no-fly and selectee lists. Gilmore alleged that these government security policies and provisions violated his right to due process, right to travel, right to be free from unreasonable searches and seizures, right to freely associate, and right to petition the government for redress of grievances. The district court dismissed Gilmore's due process claim because it lacked jurisdiction to hear it. The district court, however, did not assess whether it had jurisdiction to hear Gilmore's other claims. Instead, it reached the merits of those claims and determined that each one fit. In granting defendants' motions, the court, noting that the ID policy had been classified as SSI, did not review any official documentation of the ID policy. Rather, for purposes of its jurisdictional ruling, the district court assumed, as Gilmore alleged, that the ID policy was a security directive issued by TSA. Gilmore timely appealed. Shortly after oral argument in this case, the Ninth Circuit ordered the government to file under seal the relevant material pertaining to the ID policy so that they could conduct an in-camera ex parte review. So what is the issue? Whether the government's failure to provide adequate notice of the law violates his right to due process and renders the law unconstitutionally vague, whether the ID policy violates his constitutional right to travel because he cannot travel by commercial airlines without presenting ID, which is an impermissible federal condition, and lastly, whether both options under the ID policy, presenting ID and undergoing a more intrusive search, are subject to Fourth Amendment limitations and violated his right to be free from unreasonable searches and seizures. So the holding. The court held that defendants did not violate Gilmore's constitutional rights by adopting and implementing the airline ID policy. Therefore, his claims fail on the merits, and the court denied his petition for review. Reasoning. Gilmore argued that the request for ID implicated the Fourth Amendment because the government imposes a severe penalty on citizens who do not comply. Gilmore highlighted the fact that he was once arrested at an airport for refusing to show ID and argued that the request for ID imposes the severe penalty of arrest. Gilmore further argued that the request for ID violated the Fourth Amendment because it constituted a warrantless general search for ID that is unrelated to the goals of detecting weapons or explosives. The request for ID, however, did not implicate the Fourth Amendment, according to the court. A request for ID by police does not by itself constitute a Fourth Amendment seizure. Rather, an individual is seized within the meaning of the Fourth Amendment only if, in view of all the circumstances surrounding the incident, a reasonable person would have believed that he was not free to leave. Similarly, an airline personnel's request for Gilmore's ID was not a seizure within the meaning of the Fourth Amendment. In this context, the court ruled that Gilmore had a meaningful choice. He could have presented ID, submitted to a search, or left the airport. That he chose the latter did not detract from the fact that he could have boarded the airplane had he chosen one of the other two options. Thus, the court rejected Gilmore's Fourth Amendment arguments. Gilmore argued that because the ID policy violated his right to travel, it followed that it also violated his right to petition the government and freely associate. These claims, as Gilmore argued in his appellate brief, were based on the notion that freedom to physically travel and the free exercise of First Amendment rights are inextricably intertwined. Here, this logic worked to Gilmore's detriment, according to the court. That is, even accepting Gilmore's assertion that there was a connection between the right to travel and First Amendment freedoms, his argument failed because, as the court explained, his right to travel was not unreasonably impaired.